Welcome to Talking Business, your straight-talking guide to dealing with corporate matters. Whether you are a private or public company, an owner-managed business or an entrepreneur, a director, company secretary or in-house counsel, this is the podcast for you. My name is Sophie Brooks and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, welcome to the latest edition of our Talking Business podcast. So this month saw the first really significant changes for companies come into force under the Economic Crime and Corporate Transparency Act. Bit of a mouthful, but we're calling it ECTA. So I thought we would have a look at all those changes first, and then we'll consider a couple of cases. But first up then, ECTA. So this has been on the horizon for quite a while now, and it received royal assent, so it became an Act of Parliament last year, but now we're beginning to see the first practical impact with various changes coming into force that are affecting companies from the 4th of March, so hot off the press. So in particular, the stuff that's coming on the 4th of March is new rules about a lawful purpose statement, new rules about a requirement for a registered email address, and some new rules around registered office addresses. There's some other stuff as well, but those are the kind of big things that are going to have an impact on companies. So I thought we'd look at those. So first up, that lawful purpose statement. So now, post 4th of March, when a new company is incorporated, the subscribers, so the people who subscribe to the memorandum and take a share on the incorporation, they have to confirm that the company is being formed for a lawful purpose. There's then a continuing obligation for all companies, so all existing companies and all new companies formed after the 4th of March, to confirm in their annual confirmation statement that they file at Companies House that the company's future activities will be lawful. The next thing that I mentioned was the registered email address. So now all companies have to provide what's called an appropriate email address to Companies House. And an email address will be considered appropriate if it's one that emails sent to it by Companies House would be expected to come to the attention of someone acting on behalf of the company. So that email address is not going to be publicly available, importantly, and it's only going to be used by Companies House to communicate with the company. So probably to send you reminders about filing deadlines and chivvy you along if you miss any of those. New companies, again, will have to provide an appropriate email address on incorporation, and existing companies are going to have to provide one with their first confirmation statement filed after the 4th of March. So your confirmation statement is a snapshot of the company that you have to file annually, and when you do that the next time, you're going to have to complete and file an appropriate email address. And then the other thing that I mentioned was the requirements relating to a company's registered office address, which have changed. So all companies now have to have an appropriate registered office address. So that's a physical address where documents delivered to it would be expected to come to the attention of someone acting on behalf of the company, and where an acknowledgement of delivery can be obtained. So some companies, rather than using sort of their own principal trading address, some companies use a third party's address as their registered office address, maybe their solicitors or their accountants, something like that. You're still going to be able to do that, provided obviously that that third party has appropriate procedures in place to monitor and forward any post received, so that post at that received at that address would be likely to come to the attention of someone acting on behalf of the company. Again, new companies will have to provide an appropriate registered office address when they are incorporated, and existing companies that don't currently have an address that falls within that definition of appropriate, so maybe because their current registered office address is just a PO box, something like that, they will be asked to change their address when they file their first confirmation statement after the 4th of March. So there are a couple of other changes that have come in, which I think perhaps are a sign of things to come, really. So, in particular, Companies House fees are going to be increasing from the 1st of May 2024. So, you'll be familiar with the fact that when you file lots of things at Companies House or are doing something at Companies House, you have to pay a fee to go with that. So, those fees are going up, and that's because under ECTA, the scope of activities which can be funded through Companies House fees has expanded to include the cost of investigation and enforcement activities. And the scope of those investigation and enforcement activities has significantly expanded. Companies House are going to be a much more proactive gatekeeper of accurate information. That obviously is going to involve more time and resource at Companies House, which has to be paid for. And part of the way that that's going to be paid for is by this increase in fees. So some of the fees have increased quite significant. They're not necessarily big amounts in themselves, but the percentage increases have been quite significant. So a digital incorporation of a company used to cost £12, now that's going to be £50. A digital same day change of name is going to be £83, up from just £30. And a digital reduction of share capital filed via the Companies House upload service is going to be £136. It used to be just £50. Um, I mentioned there all the ones that I was giving you examples of there were digital filings. You can still make paper filings, but they will be more expensive than if you use the digital equivalent. So those fees are all going up from the 1st of May. But then, quite importantly, there's going to be some new regulations which give the Registrar of Companies the ability to impose a financial penalty on a person if satisfied that an offence has been committed under the Companies Act. So they're going to be able to impose a penalty of up to £10,000 directly as an alternative to a criminal prosecution. And those regulations, as far as we know at the moment, are likely to come into force on the 2nd of May. So companies are going to see a whole raft of changes introduced throughout 2024, maybe even into 2025, as a result of ECTA and this increased role that I've talked about that the registrar is going to have as a gatekeeper of accurate company information. Historically, with the only situation really in which you tended to get fined by Companies House was when you filed your accounts late. And you always knew if you missed your accounts filing deadline, you were going to get a financial penalty imposed. But actually, for all the other offences under the Companies Act, the registrar tended to take a pretty light touch approach. So, if you filed a form late, so recording a form, perhaps recording the resignation of a director, it has to be filed at Companies House within 14 days. And if you miss that deadline, it is a criminal offence. But historically, actually, nothing has really happened if you filed that form late, um, partly because of the prohibitive costs of pursuing that via a criminal prosecution. But now I think with this ability for Companies House just to impose a direct financial penalty, I think that coupled with the increased fees is all pointing towards a much stricter approach coming down the line. So I would strongly suggest that companies start to prepare for this new world now by making sure that all their records are up to date, both their internal records and those that are maintained at Companies House, and then ensuring that you've got appropriate procedures in place to uh, enable timely compliance with all the relevant deadlines and requirements in the future. So some things to think about there, definitely. Okay, but that's enough about company administration for now. So let's have a look at a couple of cases. So the first one that I've got was a case in the High Court where the court held that a contractual limitation of liability clause did not apply to a party's obligation to pay for the actual goods supplied under the contract. So the court said that that was a primary obligation to pay, which amounted to a debt, and it was separate from the party's secondary obligation to pay damages arising out of its failure to pay for the goods. So the limitation of liability provision applied to a claim for damages, but it wasn't sufficiently clear so as to limit that primary liability for a debt. So just in relation to limitation of liability clauses then, so it's pretty common for commercial contracts to include a limitation clause which attempts to limit the potential liability of one party if there's a claim by the other counterparty. If you don't have a limitation clause, then where there's no financial limit on the damages a counterparty could recover. So if you want to reduce your potential exposure, you need to include an express limitation of liability clause in your contract. If you haven't got anything in there, then you've effectively potentially got an unlimited liability. If you have got a clause, a well-drafted limitation of liability clause can clearly detail the claims that it's intended to cover. So, for example, breach of contract and negligence. And if a provision comes before the court, then the court will have to decide whether, as a matter of contractual construction, the clause extends to cover the obligation or liability that a party is seeking to restrict. And the party that's relying on the provision, so the party that's saying, no, our liability is limited here, is going to want it to be as unambiguous as possible, obviously, whilst ensuring that it's not so widely drafted that it's unenforceable. So, in the particular case in question here, there was a dispute arising out of non payment by a customer for goods supplied to them by a supplier. The supply agreement contained a clause which restricted the total liability of either party in respect of all acts, omissions, events, and occurrences, whether arising out of tortious act, breach of contract, or statutory duty, or otherwise. And when the supplier sued for payment of the goods, the customer argued that the limitation clause, and in particular the fact that it had those words breach of contract or otherwise in there, that clause, they said, limited their liability to pay for any goods supplied to them. But when it came before the court disagreed with the customer and held that the limitation clause was not effective to limit their liability to pay for the goods supplied to them. As a matter of construction, the limitation clause only applied where there'd been a tortious act, a breach of contract, or statutory duty. But the court said, look, the amount owed by the customer for the supplied goods is a debt. It's a primary obligation under the contract. And enforcement of the debt had to be distinguished from any claim for damages arising out of the fact that non-payment of the debt was also a breach of contract. So, although the limitation clause may have been effective to limit contractual damages arising from the breach, it was not effective to limit a claim in debt for the price of the supplied goods. And to do so would have required very clear wording. And the court said, look, just including the words or otherwise, that's not sufficiently clear to exclude a claim relating to the enforcement of a primary obligation. So I think this case is quite a good illustration of the importance of setting out as clearly as possible exactly what liabilities are intended to be caught by that kind of limitation of liability provision. As I say, they're pretty common in commercial contracts. And the High Court really, in this case, took quite a commercial approach to the interpretation of the limitation clause and held that it didn't apply to the obligation to actually pay for the supplied goods. It's almost like a stage after that. So you've got to pay for the supplied goods, but then if there's a claim for damages, then potentially the limitation clause would apply. But it did say, the word liability is a very wide concept. and a limitation provision could arguably be drafted so as to expressly restrict a primary liability, such as an obligation to pay for the price of the goods or even to pay interest on a debt. It would be unusual to have such a widely drafted clause, but even if the interpretation of a clause leads to an unexpected or commercially unusual outcome, a court will be bound by the express wording, unless the clause happens to be unlawful. So, because of that, the parties would be very well advised to ensure that they understand the full consequences of any contractual limitation provision and that those provisions reflect accurately the agreed intentions of the parties in each case. Okay, so that was limitation of liability clauses. The second case that I thought I'd mention this month is one in which the High Court held that one party had breached the fiduciary duties it owed to another as a result of its wrongful exploitation of certain business opportunities that had been disclosed to it during the course of merger negotiations between the two parties. It's quite an interesting case because it's pretty unusual for fiduciary duties to arise in purely commercial relationships outside of the sort of established categories where we see fiduciary relationships, so things like agency or partnership. So let's have a bit of an explainer about fiduciary duties. So a fiduciary will owe strict duties to the other person that is in that fiduciary relationship. So, for example, a director owes fiduciary duties to a company. The director, if you like, is the agent of the company. The company is the principal. Same thing with, say, trustees owing fiduciary duties to the beneficiaries of the relevant trust. Now, the scope of those duties owed in any given case will ultimately depend on the nature of the particular relationship. But essentially, a fiduciary will owe a duty of loyalty to the principal, which involves being guided solely by the interests of that principal, the other person in the relationship, and not by any consideration of the fiduciary's own interests. So, if you like, the fiduciary has to subordinate their own interests to the interests of the principal in the relationship. So, in a commercial setting, it's normally inappropriate, I would say, to expect one commercial party to subordinate its own interests to those of the other commercial party. But this case does show that contractual and fiduciary relationships can coexist between the same parties. And in fact, the existence of a contractual relationship may provide a foundation for the establishment of a fiduciary one. So, in this case, there were two parties. I'm going to call them Party A and Party B. And they had engaged in discussions relating to a potential merger of their businesses. So they never actually entered into a formal agreement. But Party A said that they had reached an oral agreement on the terms of the merger. Party B disagreed, arguing that actually no final agreement between them had ever been reached. So during the merger discussions, Party A informed Party B of a business opportunity with an insurance customer. And according to Party A, the parties had agreed that that opportunity belonged exclusively to Party A and that Party B would only benefit from it if a merger was concluded. Now, despite the merger not taking place, and Party B not paying Party A anything in respect of it, Party B went on to exploit the opportunity for its own benefit and it earned revenue from it. So, perhaps unsurprisingly, Party A brought a claim against Party B for breach of contract based on that alleged oral agreement. Remember, you can have an oral contract. So they claimed for breach of contract, but they also claimed for breach of fiduciary duty. Now, in this case, the court found on the evidence that the parties had, in fact, made an oral agreement along the lines of the one that Party A alleged existed. And on that basis, party B had been in breach of that contract when it pursued the opportunity for its own benefit. So there was a contract, albeit it was an oral contract, and party B was in breach of that contract. Now, as regards the claim for breach of duty, breach of fiduciary duty, the court held that yes, there had been a fiduciary relationship between party A and party B in relation to this particular opportunity. That fiduciary relationship was based on the oral agreement that had been reached between the parties, under which practical control of the opportunity had been passed to party B to be exploited exclusively for party A's benefit in the absence of any formal merger taking place. And party B had undertaken to act on behalf of party A in circumstances which gave rise to a relationship of trust and confidence, and it's that relationship of trust and confidence that leads to the existence of fiduciary duties. So the judge did say that fiduciary duties are not readily found in commercial settings due to the fact that each party is usually entitled to primarily look after its own commercial interests. But in this case, the terms of the agreement between the parties in relation to the opportunity did not allow party B to prefer its own interests. So the fact that the parties trusted each other was not of itself determinative of a fiduciary relationship. Parties can trust each other without creating those critical fiduciary duties. More is required to establish a fiduciary relationship. One party must be in the position where they trust and confide that the other party will act exclusively in the first party's interests. And that, the judge said, was exactly the position that we were in here. As a result of the agreement between them, Party A trusted that Party B would act exclusively in Party A's interests in relation to the opportunity, and that Party B would not benefit from that opportunity unless there was a merger successfully concluded. So, in a perfect world, parties involved in pre-contractual negotiations will have agreed binding restrictions on the use of those kind of confidential business information and potential opportunities that are disclosed during their negotiations. Those restrictions in themselves should relate not only to the period whilst negotiations are ongoing, but also for a specified period after the end. So, as happened here, there were negotiations between them, they came to an end, and then the opportunity was exploited. But even if contractual restrictions are not in place, then parties need to be very wary of exploiting confidential information that's been disclosed to them. As we saw in this case, it is possible for commercial parties to owe fiduciary duties to each other. And those fiduciary duties will then be breached if one party exploits that confidential information at the expense of the party to whom the duties were owed. So remedies that a court can impose for breach of fiduciary duty include things like compensation, injunctive relief, and an order for account of profits, where the party in breach has to account to the other party for any profits gained from their wrongdoing. So an interesting case, really, because it's imposing those fiduciary obligations and duties in a context in which we haven't really seen them being imposed before. So definitely something for parties engaged in those kind of negotiations, disclosing and receiving confidential information to watch out for, I think. Okay, that's it for this month. Hope you found that interesting, and I'll speak to you again soon. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.